அதில் கனெக்ட் பண்ணி டிவியில் ஸோ அது டிவியில் மட்டும் அதை கனெக்ட்
Good morning to all. On behalf of the organizing team, I welcome you all for the pattern workshop. The program will start in 10 minutes. Good morning, ladies and gentlemen. A patent gives one the right to stop others from copying, manufacturing, selling, or importing without seeking one's permission. Yes, today, the Internal Quality Assurance Cell of Annamalai University and Center for Intellectual Property Rights of Annamalai University jointly organizes the one-day virtual workshop on effective drafting and filing of patents. On behalf of the organizing committee, a warm welcome to one and all present online. Let God's blessings be bestowed on all of us. Let's start the program with invocation, followed by tribute to our founder, Pro-Chancellors.
நீராறும் கடலுடுத்த நிலமடந்தை கெடிலொழுகும் சீராறும் வதனமென திகழ்பரத கண்டமிதில் தெக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம்பியந்து செயல் மறந்து வாழ்த்துதுமே 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 தில்லை பதியுடைய சிற்றம்பலம் தன்னில் அல்லும் பகலும் நின்று ஆடுகின்றார் எல்லை அண்ணாமலை அமைத்த கலை கழகம் கண்ணார கண்டு கழித்து நில்லாத செல்வத்தை நிலைக்க செய்தார் நீங்காத கலை புரட்சி நிரம்ப செய்தார் கல்லாத இனமெல்லாம் கற்க வைத்தார் காணாத பெருங்கடலும் களத்து வைத்தார் இல்லாத புலவர்களை இருப்போராக்கி இணையாத தமிழ் புகழை ஈட்டிக் கொண்டார் வெல்லாத செயலில்லை என்று போற்ற விளங்கியவன் மண் அண்ணாமலையான் வாழ்க மணி காட்டும் உயர்ந்த நெஞ்சும் மலை காட்டும் அகலம் விரிந்த நோக்கு பணி காட்டும் திருக்குறளில் படிந்த வாழ்வும் பதவியெல்லாம் படி போன கடந்த பாங்கும் அணி காட்டும் தாமரை அடைந்த மார்பும் ஆரையும் அனைக்கும் கை பிணி காட்டும் மருத்துவன் போல் பேணுவன் பெற்ற தமிழ் முத்தையவள் பெரியோன் வாழ்க பெற்ற தமிழ் முத்தையவள் பெரியோன் வாழ்க பெற்ற தமிழ் ராமசுவாமி பெரியோன் வாழ்க பெற்ற தமிழ் ராமசுவாமி பெரியோன் வாழ்க.
Thank you, sir. Professor S. Nambi, Director of IQAC and Head Department of Entomology, is a person of simplicity and sincerity. He is a strong believer of teamwork and knows the way of getting things done. Sir will now welcome the gathering.
Very good morning to everyone present here and the participants and other chief guests online. It's my privilege to welcome you all.
Sir, you are muted. Please.
Yes. So I actually welcome the guest of today, workshop Professor IQAC-ANNAMALAI, Dean Faculty of Agriculture, Annamalai University. She is a well-known soil scientist and a popular teacher, able administrator. She is actually the role model for many of the girl students in the Faculty of Agriculture. She is always supporting us and motivating, even because of her support only, we are conducting such an activity in this university. On the behalf of the team IQAC and the director CIPR, I welcome the Dean Faculty of Agriculture, Madam Dr. IQAC-ANNAMALAI for this workshop. Welcome, ma'am. I welcome the special guest of this particular workshop, effective drafting and filing of patents today, Dr. Sharan Gowda, Assistant Controller, Patent Government of India, Chennai. Actually, he is a very simple personality, but straightforward man. He is actually readily accepted our invitation to actually present about this effective drafting and filing of patents. Actually, in addition to this, he is kind enough to issue Government of India certificate to all the participants of this workshop. Sir, this is actually online workshop. In future, we will have a lot of collaboration, even offline programs we will conduct, sir. On the behalf of the organizing committee, I welcome you all, and I especially welcome Dr. Sharan Gowda, Assistant Controller, Patent Government of India, Chennai, for this workshop.
Thank you, sir.
Welcome, sir. I welcome Dr. V. Manikam, Professor, Department of Electronics, St. Joseph's College, Tiruchirappalli, who readily accepted our invitation to be a part of this particular workshop. And he is a very busy personality. He is conducting a lot of awareness programs related to this patent. On the behalf of the organizing committee, I again welcome Dr. V. Manikam, Professor, Department of Electronics. Welcome you, sir. I welcome Professor J. Jayabharati, Head Department of Chemistry and Director CIPR for this workshop. I welcome all the Deputy Directors of IQAC and even the organizing secretaries and other joint secretaries for this workshop. I welcome Dr. Rajesh, Assistant Professor in Music to this workshop. And I welcome Dr. P. Sivagurunadan, Deputy Director, CIPR. Actually, I consider myself blessed to work with the team of IQAC and the other supporters like Dr. K. Pravina, Dr. J. Tamilselvi, and Dr. K. Sai Leela. So I welcome all the joint secretaries. In addition, Dr. S. Ramesh Kumar, Deputy Director, IQAC, Dr. S. Karthik Kumar, Deputy Director, IQAC, Dr. Sellamuthu Kumaran, Deputy Director, IQAC, and K. Sanjeev, Deputy Director, IQAC. And the person who is actually involved in the organizing this particular workshop, Mr. K. Jayaprakash, is also a Deputy Director, IQAC. Without his hard work, these types of functions are not at all possible in IQAC. I wholeheartedly welcome Mr. K. Jayaprakash, Deputy Director, IQAC, once again for this. Finally, I welcome the participants who are all online. Again, you can hear the talk from Sharan Gowda. This is a cool morning, but his talk will be a warm for us. Thank you very much.
Thank you, sir. Next, we have with us Madam A. Angair Kani, Dean Faculty of Agriculture. She is an expert in the field of soil sciences. She is highly motivating and an inspiring teacher. She has a vision for the development of the faculty. Madam will now deliver the inaugural address. The platform is yours, Madam.
Thank you, Madam. So good morning to all. Beloved Director, IQAC, Annamalai University and Professor and Head Department of Entomology, Dr. S. Arivude Nambi. My friend, Dr. J. Jayabharati, Director, Center for Intellectual Property Rights, Annamalai University and Professor and Head Department of Chemistry. Special guest, Dr. Sharana Gowda, Assistant Controller of Patents, Government of India, Chennai. Dr. V. Manikam, Professor, Department of Electronics, St. Joseph's College, Tiruchirappalli. Deputy Directors, Organizing Secretaries of this workshop and their participants. I'm very happy to inaugurate this workshop, which is being organized by the team IQAC and Center for Intellectual Property Rights, CIPR, to guide all our staff members as well as research scholars in the process of effective drafting and filing of patents. I compliment the team IQAC and CIPR Annamalai University for organizing this workshop at a time when quality has become the buzzword in every sphere of activity. More importantly, the yardstick of quality in education is being revisited in terms of innovation and contribution to knowledge-based economy. So the need to change our attitude towards quality is stressed by a dismal share in the global applications being filed for patents. India's share in the global economy in terms of research citations is lagging by 3.1%, and India's efforts in filing patents and in ensuring better research output has to be increased by strengthening the knowledge base of our faculty members, and also by updating our syllabi and strengthening and teaching methodology. For this, every other matter has to be second to quality consciousness. The fundamental idea for patenting is only to safeguard our inventions that are created and therefore encourage more developments. Intellectual property has always played an increasingly significant role in today's technology-driven society. Patents are an important, very important asset for an organization, especially education institutions. The innovative strength of an organization can be measured through its patenting activities. Not just the number, the quality of patents is equally important. Granting a patent is a very long drawn process that actually entails multiple checks on novelty and industrial applicability of the invention. A patent granted by the government gives an exclusive right to the inventor to make use and sell his invention. This exclusive right is only for a limited period, that's for 20 years from the date of filing. Not all inventions are patentable subject matter. Patent Act provides those subject matter which are not patentable. Therefore, the inventor must be clear of his invention and he must always find out whether his patent falls or does not fall under such of those categories which are not patentable. The application consists of various parts. Filing is also equally important. Not only drafting, filing is also equally important. The application consists of various parts such as claims, background, description, drawing, if there are any drawings, abstract and summary. All such parts must be carefully drafted to provide effective disclosure of the invention for which this workshop has been organized. Utmost care and precision must be taken while drafting the application. After drafting the patent application, this can be filed. Filing is quite a serious process which has different steps involved. I'm sure that the speakers of the day, Dr. Sharana Gowda, Assistant Controller of Patents, Government of India, Chennai, and Dr. V. Manikam, Professor, Department of Electronics, St. Joseph's College, Trichy, will elaborately explain to us the steps that are involved in patent filing and drafting and the do's and don'ts of filing a patent. I sincerely thank both of you for accepting our request to deliver your special address through virtual mode. I'm happy that the IQAC and CIPR of Annamalai University, which have already established their stature by ensuring a laudable level of quality, are hosting this initiative. I wish this workshop all success and would certainly look forward to see the outcomes. I compliment the organizers once again, especially for giving me an opportunity to inaugurate this workshop and for conducting this workshop through virtual mode for the benefit of all the staff and research scholars. Thank you once again.
The importance of patents and how it is especially important for higher education institution was well given. And you have also highlighted the how to file patent was also given by you. Thank you, Madam, for the inaugural address. Now we have with us Dr. Sharana Gowda, working as Assistant Controller of Patents from Government of India, Chennai. A brief intro to him. He has his PhD in biochemistry from Gulbarga University, LLB from Bombay University. He has his diploma in fostering innovation and commercialization of IPR from Denmark. He has served as the coordinator for the Patent Office India and National Biodiversity Authority. He is a member of the Expert Committee on ABS of Biological Diversity 2002. He has 18 years of experience at Patent Office. He is the recipient of Young Scientist Award from NISA, New Delhi, and he has delivered 200 lectures related to patent system of India and its role in development, and also on IPR along with biodiversity issues. Sir will now give a brief introduction to the patents.
Yeah, good morning, everybody. So I'm very thankful to be part of this workshop, one-day virtual workshop. So for this, I am thankful to Annamalai University and the organizers, mainly the IQAC and CIPR team of Annamalai University. So, ma'am, Dean Madam, so and other faculties and students who are all joined. So, to learn about effective drafting and filing of patent applications, and this, so a special thanks to Karthik Kumar sir and other organizing secretaries and joint secretaries. So as Madam pointed out, this is a very important and a knowledge-based economy. So what we are at the stage in the globalized era, so we are having a knowledge-based economy, which we need to protect our knowledge. If knowledge is not protected, so it will be anyone's property. So that is the situation we are in. So the madam truly pointed that, so in the Patents Act, we cannot grant everything, whatever under the sun, you cannot get a patent for everything. So rightly pointed, but still within that, so wherever the technologies require the protection for 20 years term, so they can enjoy the benefit and the monopoly right within that. So in the globalized situation, so we are in a position that we can accelerate this knowledge-based economy to improve the economic status of a country. So last month in October 2022, so WIPO, World Intellectual Property Organization, released the ranking. So every year there will be a global innovation index. They will give among 193 countries, so they will rank. So India, of course, it has jumped a lot when you compare to 2015, we were at 86th position. Now we are at the 40th rank. So of course we are coming, but in economic perspective, so India stands at 5th position in the global scenario, but we are not in top 10 of the global innovation index because of we are not protecting whatever we are inventing, whatever we would have been, it should have been protected. It will give advantage to our researchers, but we are not taking the benefit of that. So in that way, the organizers of this workshop, very good theme selected, that is effective drafting and filing of a patent application and present situation at the patent office. So as Dean Madam pointed about the delays, maybe 4 years, 5 years, it is the past. Now we are quick enough to serve all the research community in a faster and better way. So because we were having earlier the backlog in the patent office, we were taking lot of time. So now we are not in that situation. So it will be a maximum 2 or 3 years. It will be in some fields of technology, especially in chemistry, you can expect that a patent grant within 1 year, and in other fields it may take 2 years. So in biotechnology there is a still little bit tendency. Because of that, there may be around 2.5 to 3 years it may go. But so it will be definitely by one and a half year, it will definitely improve the situation to serve you. And government of India has introduced a lot of schemes also. So there is a scheme, expedited examination. So if all are natural persons and women, one of the women is a applicant, then they can opt for the expedited examination, and within 8 months you will get a grant of a patent. So that will be the speeding up of the process. And also the all educational institutes, whether it is Annamalai University or any research faculties, they want to benefit of educational institute. Being educational institute, they can get the 80% concession in the fee. So these schemes, of course, has improved the filing of in India. Last in 21-22, we were at 66,000 patent applications filed. But if you compare with the other developed nations, we are not filing or protecting. So of course, we may be around more than 40% of domestic filing has increased. So it has come a little bit more presently. So maybe around 40 to 45% our Indian domestic filers, applicants, maybe from majority from the academic institutions. So if the academic institutions are well aware of these protections, which whatever they are creating in their laboratory, so they are protecting, then they can serve for the industry. Industries definitely they will come for the technology transfer to the universities. So the conventional way of filing was not there. They were not looking because the patent was taking a lot of time or it is a cumbersome process. But as far as I'm concerned, from the patent office perspective, it's a very easy process. We are trying to make simpler day by day the process for our academic researchers or industrial researchers. But what was the lacuna is that since they are not protecting, so industries were not coming to them for technology transfer. Once all the academic researchers, instead of filing, that is publishing, before publishing a journal in the journal, peer reviewed journal, so maybe any high impact factor, so you can just file for a patent application and then publish. Very next day you can go for the publication. So that will protect your rights. If you are all protected, most of the research work, whatever it is, if it is applicable for the industries, then they are not having any option. They have to come to researchers for the technology transfer. So right now what is happening is, so most of the research is free for them because they are available in the journal publications. So because of that, the industries are not approaching the universities for technology transfer. If you are providing a monopolized technology, any industry can definitely approach you for the technology transfer. This is the definitely it will be in next 10 years. It will definitely happen that most of the research, whatever the commercialization they want, so they have to come to academic researchers who have protected through their patent. So in that way, so this workshop definitely will provide a lot of inputs for protection and how one can file a patent application, how effective drafting can be done, because the whatever you have done in the laboratory will never be seen by anyone, but whatever you have written in the draft is seen by anyone by the publication of your patent application. So, and we are granting not on what you done in your laboratory. It is mainly what you have filed in the patent application that will matter most for us, because how you have written and how much the broader or narrower or whatever the scope you have protected, is there any scope for the trespassers? All these things will be seen with that. And what, as Madam pointed, so the novelty, inventive step, and industrial applicability will looked upon how you are drafting a claims, the whatever you have given a description. So that will matter most for a patent application, rather than, because in my experience I can say that people will do the great work, but they will not present the great work which is on the paper. So when they are not presenting, so examiner in the patent office will never come to know that what is their invention. So then we are in difficult situation. So we are not able to understand the invention. So that is, I definitely think that this type of workshops will definitely give lot of inputs to our researchers or innovators in solving this issue, how one can make a proper draft of a specific patent specification and take the advantage, because the drafting is the major theme. So where you will get a patent for that drafted one. If you are poor drafting, even though you get a patent, it's of no use, because it's not it cannot serve the purpose in providing monopoly to you. So drafting definitely serves a purpose when you make a proper draft of a specification. So I congratulate, and I once again say all the best for the program, and also I thank for inviting me for this, giving me an opportunity to speak on this occasion. Thank you.
Thank you, sir, for the nice intro. We can continue to listen to sir after the vote of thanks. Now I request Karthik Kumar sir, the Deputy Director of IQAC, to propose the vote of thanks.
Most respected Dean, Faculty of Agriculture, Annamalai University. Most respected Dr. Sharan Gowda, Assistant Controller of Patents, Government of India, Chennai. Professor Dr. S. Ariudainambi, Head, Department of Entomology, Director, IQAC-ANNAMALAI University. Professor J. Jayabharati, Head, Department of Chemistry, Director, CIPR, Annamalai University. All my friends, come fellow faculty in the IQAC-ANNAMALAI University, secretaries and joint secretaries of this one-day workshop, and above all, the dear participants from across the country who have enthusiastically joined this online workshop. Wish you all a very pleasant morning. The one-day workshop on effective drafting and filing of patents was planned about 10 days ago, and the brochure was released just a week ago. But in spite of that, the program has become a grand success with more than 300 participants from across the country. It is all due to the extraordinary cooperation that we received from a number of people, and I'm here to thank each one of you. I take this opportunity to express my sincere gratitude to Dr. A. Angayar Kanni, Dean, Faculty of Agriculture, who readily consented to our request to be the guest for the inaugural program of this one-day workshop. Ma'am, thank you. Thank you for readily accepting our invitation, and thank you for your patience as well as passion to be with us, to have spent your time with us this morning. And we also thank you for your wonderful and crispy inaugural address. Thank you, ma'am. Thank you very much.
Thank you.
Our sincere thanks go to Dr. Sharan Gowda, Assistant Controller of Patents, Government of India. We just sent a message by WhatsApp. Immediately he responded without any hesitation. It is said, to be great is very simple. but to be simple is really great. And we have such a great personality who is simply great and greatly simple. Sir, we owe a lot to you for your extraordinary cooperation, which has enabled us to have this program today. We are thankful to you for accepting our invitation to be one of the resource persons to address the audience on a very relevant topic. As our director pointed out in the welcome address, we would approach you very often in the interest of the participants and faculty from various institutions. Hope we can collaborate a lot. And I take this opportunity to record our sincere gratitude to you for being with us and for your acceptance. Thank you, sir. Thank you very much.
Thank you. Thank you.
Our sincere thanks are also due to Dr. V. Manikam, the resource person for the session 2. He is also a busy faculty and speaker who delivers lectures on filing of patents. He also readily accepted our invitation and he has agreed to be the resource person for the session 2. He will be addressing the audience in the afternoon. Though he could not join for the inaugural session, we place on record our gratitude to the resource person for the afternoon session, Dr. V. Manikam. My sincere thanks are due to all the deputy directors, secretaries, and joint secretaries of this one-day workshop. It's actually a teamwork. Without this team, any program of this type could not be imagined. We have with us our boss, our team leader, Dr. S. Ariudenambi, Professor of Entomology and Director IQAC. It is his presence behind us that gives us courage to undertake a program of any type, even within a very short notice of time. His very presence is a very courage for us. It's a moral courage for us. So on behalf of all of us here, I express my sincere gratitude to our director, Dr. S. Ariudenambi. This program has attracted within a very short notice of time more than 300 participants from all over the country. It shows the immense trust that the participants have on the IQAC-ANNAMALAI University. Dear participants, thank you for joining. Thank you for registering yourself for the workshop and joining us online today. I assure you that we will keep up the trust that you have on us, and we will continue to work for you, and we will come up with more number of programs in order to benefit you. So thank you for registering yourselves, and thank you for being participants today. The thanks are due to all the secretaries and joint secretaries of the one-day workshop. My special thanks go to Professor Dr. Rajesh, Assistant Professor of Music. Despite being a holiday today, he has come just to render the invocation and the founder's anthem. Thank you, sir. Thank you very much. My sincere thanks are also due to Dr. Praveena for being the master of ceremony today. So once again, I thank you all. Thank you very much.
Thank you, sir, for the vote of thanks. Now we listen to Sir Sharana Gowda, sir. Sharana Gowda, sir, will continue now.
Yeah. Can I share my presentation, ma'am?
Sure, yes, sir. Yes, sir.
Sharing option is not coming. So thank you, ma'am. So for giving me this opportunity, I think can I have a sharing?
Sir, you are co-host, sir. You can share, sir.
But that okay, yeah.
Yes.
Okay. So hope the presentation is visible to all.
Yes, sir.
So,
Yes, sir.
yeah, filing of patent application. So I'm just dealing with that in that. So I will address the drafting and where it is most important. I'll just take and what are the parts we look at the patent office. So when we want to monopolize our invention, so whether it is of any subject, so whether it is a device or chemical compound or a biotechnology product, so our composition or matter, anything, so we need to look into the aspects where the patent office looks on those things. So what a patent application, when it is granted, it will be a patent, and that patent will give you monopoly for 20 years from the date of filing. Whenever you are filing a patent application, so its expiry date is fixed on the filing date itself. Today, if anyone on 11th November 2022, if anyone files, its expiry date is 20 years from today, that is 11th November 2042. So no extension can be given for that. So for to get that 20 years monopoly, so what one has to need is that he has to file a patent application. So we are not looking at the invention and whether you have done or not, all these things we are least concerned with that. We are important step is that whether you have filed it or not. So from the filing date only we will count that you have done a invention, so not the invention date. So whoever files a first, that is first to file, they will be awarded a patent. That's why the filing becomes very important. And what this 20 years monopoly, how you will get, since the patent office will publish whenever you file a patent application with forms which are mentioned, I will detail on that. So with that, you will be from the publication date, you will be protected from the use by the competitors. That is what we call it as infringement. If anyone without permission or license from you, he uses, he will become a infringer. So that is, so for that, what is the requirement? First and foremost, to file a patent application, you require a invention. So now what is the invention? So patent is granted under the Patents Act 1970. Even in the British period also we were granting patents in India, and post independence from 1970 Act, Patents Act 1970, which is in enforce from 1972. So it is, we are looking the patent grant with respect to that Patents Act 1970, which has been amended 3 times because of the, when we joined the GATT agreement and on that TRIPS agreement. So based on that, we have amended our law. The latest amendment is 2015 amendment, which we are giving a product patents in the field of food and chemicals or drug. So for this you require invention. So what is the invention under the Act, which is defined under section 2 subsection 1 and clause J of the Patents Act defines that it is, invention means a new product or process involving an inventive step and capable of industrial application. So this definition under the Patents Act is having 3 criteria. Even Dean Madam pointed during the inaugural address itself. These are the 3 criteria where Indian Patent Act defines for an invention. Not only Indian Patent Act, almost all the patents acts in the world are depending on these 3 criteria. That is novelty, inventive step, and industrial applicability. You want patent in any country, you need to have these 3 minimum requirements. Without that, you will never get a patent in any country. So because in a, this is a, what we are talking is a IPR or patent is a territorial right. So in each country you need to take, then only you will get a enforcement in that country. You can enforce according to the laws of that country. So now this three criteria, novelty, that is newness, or inventive step, capable of industrial application, when we'll see the details of these three criteria, new or novelty. So what is this? It is not published before the date of patent application. So if anyone is filing today a patent application on 11th November till 10th, that is 11th November 2022. So till 10th November 2022, whatever there in the public domain, it will all be considered as a prior art or state of the art or prior art. If it is relevant, it will be cited to you. So it can be either in journals, it can be in patent specifications, earlier publications, or anywhere it is published in the websites. It can be anywhere. So that all will constitute a public domain. So in that public domain, it should not have been published. So if it is not published anywhere in the public domain, then your patent, whether you are filing for a product or a process for making that product, so you can get a criteria established, that is novelty. It is very simple. Even through the Google patents or google.com, you can check that whether is there the same product or process in the literature, patent or non-patent, both will come cover in that google.com. So if you are going for Google patents, only patents of some countries will be mainly US and European and PCT will be checked with through that. So you can search for the prior arts or the literature survey. You can do it, whether is there any product or process published, whatever I want to patent it. So that is what it will establish the novelty. If no publication found, exactly true, it is 100%, whatever I want to patent it, the product. So if the same product 100% is published in the literature, then it will lose the novelty. Otherwise, it will establish the novelty. So for the process also it is same. So if I want to protect the product made out of a process which is a 4-step ABCD 4 steps. If ABCD are not coming in any single document, then it will establish the novelty. That's how we check in the patent office the novelty of a process. So product, it is very easy. Process also, you can easily check this novelty and inventive step. Maybe it may take around 2 hours or 3 hours. You can search the prior arts. The second criteria, that is inventive step. So what is inventive step? Defined under JA clause of subsection 1 of section 2 of Patents Act, says that means a feature of an invention that involves technical advance, that is technically advanced over the compared to the existing knowledge, that is the prior art, or having economic significance, or it is economically beneficial or commercially advantageous, or it can be a both technical advance as well as economic significance. But these two things, whatever the future, what I am saying, it is a novel, and that future is not obvious to a person skilled in the art. So not obvious to a person skilled in the art. Here a little bit complication is there in determining the inventive step, because in my 19 years experience, I can say that it's not easy to determine the inventive step in all the cases. It is a little bit difficult also, but we have different methods, because different countries use the different methods to determine the inventive step. Like US PTO, United States Patent and Trademark Office, uses the TSM method, teaching, suggestion, and motivation in the prior arts. And we are generally inclined to the European Patent Office practice of problem solution approach. What they use, what was the technical problem and what was the technical problem solution by this. So in the prior art, was there any technically problem which was difficult and which is solved by this invention? So then it is inventive and not obvious to a person skilled in the art. So the person skilled in the art here is a average knowledge person who is not a PhD or the PDA, that is postdoctoral fellow, is having a average knowledge, neither illiterate in that field nor a doctorate in that field. So he is having a average knowledge in that field. So for an average knowledge person, whatever I invented is obvious or not, you have to judge. So it is definitely, I cannot say that it is very easy. So it is definitely a difficult little bit, but you leave it to the patent examiner to determine, because we have examiners who are looking at the inventive step very keenly on the each and every application, whether it is a product or it's a process or both. So we are looking here the mainly the inventive step. In 99% cases, we will say that no, it is not inventive. But then when you explain the advantages, technical advancement of your invention over the prior art, whether it is a product or process, when you say it is a surprising results are given by this product or process, then we definitely withdraw our objections. But it is a world over practice that don't be discouraged with that when we say your invention is not inventive. So it may be inventive, but we, because our examiners will get 4 to 6 hours per application to examine whatever you have done, maybe 3 years or 2 years, 5 years, some might have taken the invention to complete, and that invention he has to examine it within 4 or 6 hours. So it is a highly difficult task to understand complete invention by examiner and controller. So we generally, on a doubt basis, we generally search with the keywords for novelty. Novelty establishment will be easily done, and then we will go for the inventive step. Whatever the novel feature we are finding, and that will be judged whether is it obvious or not, with comparison to the closest prior arts. What we will make one at least 1 or 2 closest prior arts will take and compare how much difference is there. If the difference is enormous and which is not obvious to a person skilled in the art, then it is definitely inventive. If the difference is very, very minor, so then we will look into that how surprising results are given by this invention. So in that way, we generally analyze the inventive step, and with that only we will judge that whether is it obvious to a person skilled in the art or not. So, but for as an inventor, you will become an applicant when you apply. So as an applicant, you can just for a time being, you can establish the novelty, and it is for your knowledge because you have done a lot of research work for months together or years together. So you have filed after that, you presume that it is inventive, because it's not easy. One can do within 1 hour or 1 day. So if that is the case, so definitely you go ahead that. So novelty is there, and I need to not bother about much about the inventive step because it has come after a thorough research work. So then you can go for the inventive step. It is assumed that it is there. Then third criteria, that is capable of industrial application. So this capable of industrial application in relation to an invention means the invention is capable of being made in industrial scale, that is in a large scale, or used in any type of industry. It can be any, like whether it is a pharma industry, whether it is a chemical industry, FMCG, any type of industry, it should be useful to the public or the society at large. So if that is the established one utility or usefulness in any type of industry, or it can be made in a large scale, so then you will definitely establish the criteria of industrial applicability. So in these 3 criteria, this is the very easy one. You can assume that if you show one in the while drafting a patent specification, you have to write whether you are claiming a product or process for making a one product. So that product's utility, you have to mention it. So then it will establish the industrial applicability. So generally, we never object under the industrial applicability, because we presume that whatever you are claiming the product or process for making a product, so that product will be useful in any type of industry. So that way we will judge that that industrial applicability. So only the major thing is that you have to look into the inventive step and novelty. So if once you are having a novel product or process, you have developed and you have to patent it, so you can be free of that with that. So you have to write only while drafting a specification anywhere from the introduction or background to the till the claims, you can write the application of or utility of that product or product made by that process which is useful in this. So that is sufficient to establish the industrial applicability. So when I want to file a patent application, as Madam pointed in the inaugural address, so there are some inventions which are cannot be protected in India. We are not granting a patent. So which are coming under the section 3 A to P and section 4 of a patent act. So these are the two sections, that is section 3 and section 4 in the Patents Act, which will define or describe that which are the inventions which you cannot get in India. Other than those section 3 and section 4, wherever there is a product or process which establishes novelty, inventive step, and industrial applicability, all are patentable, other than whatever mentioned in the section 3 A to P and section 4. But I just want to say that still, whether it is patentable or not, you have every right to file a patent application. So we may not grant a patent on the basis of section 3 and section 4, but every patent, everything, whatever the subject matter you want to file a patent, there is no restriction for a filing of a patent application. Only for when it comes to the publication, we have a restriction that if any invention which is having a threat to the nation, that inventions will keep it for the secrecy by imposing the secrecy direction under section 35. Otherwise, all inventions will be published without any reviewing. Whatever you have given information to us, we will publish as it is to the public. There is no reviewing like in journals, peer reviewed journals, but here whatever you have given information as it is, it will be going to the public. So if that is the only screening is done at the level for a secrecy direction. If it is a dangerous invention to the nation, like making of atom bombs or nuclear bombs, such type of inventions, we will never publish it. Otherwise, we generally, as it is 99.99%, everything will go for the publication. But section 3 and section 4 are there. So for rights on those inventions which are falling under this criteria or sections will not be granted. Once it is not granted means you cannot enforce those subject matters which are there in this. Other than that, you have every right. But for filing, there is no bar. You can file any application. We will publish it to the public domain in the journal, Patent Office Journal, and that will be there in the Patent Office Journal in your name. But if you want to grant of a patent, so you need to not, that invention should not fall under the section 3 and 4. So what are those section 3? I'll just quickly go through because this will be a very, very important while drafting. So you need to make a product or process which should not fall under this section 3 and 4 of the Patents Act. So if you are making that product or process, so then you will never get a patent granted for that. It will be published, but it will never be granted. So that's why while drafting itself, you should be aware of this. Means it cannot be a product cannot be patentable, or this process cannot be patentable. So then you can draft a proper claims for that. So what are those inventions which are not patentable in India? So if you, of course, if you want to file a patent application outside India, so you can just drop a application and then you can take the priority and file anywhere outside India. Or you have a way of section 39. You can take the resident of India, anyone who has done invention in India, they can file outside India by filing a form number 25. So they can take a permission without filing patent application. You can take a permission and then also you can file outside India, anywhere in that country, like US. So there they will only judge based on 3 criteria: novelty, inventive step, and industrial applicability. If any invention which is novel, inventive, and industrial applicable, it is patentable there in US. There is no restrictions of section 3 or 4, maybe little bit, but section 3 restrictions are not there in US. So, but these are India specific. I am going to talk on that. So, any invention which is frivolous or false or anything against the natural laws, whatever we studied, the natural laws in physics or chemistry. So, against that, if anyone files a patent application, we may raise section 3A because we are studied those natural laws. So, we are doubting that. So like it is if you are selling false, but if you demonstrate, it will definitely removed with that objection. If any invention which is against the public order or morality or environment threat, if anything your invention is threat to the environment as a whole, whether it is for the plants or animals or humans or environment as a whole, so it may be objected under section 3B. Any discovery of a living or non-living thing, whether it is a isolated microorganism, bacteria or fungus or virus, anything it can be, or if it is a isolated chemicals. So from the natural compounds, generally we receive a patents for natural compounds. We generally won't grant a product per se for a natural compound which is just isolated from the plants. If you are making a composition, you can patent it. So, but you can definitely get a patent for the process of isolation, but not the isolated microorganism or isolated compound, because they are just a discovered products. So products which are discovered, you will not get a patent for them. So isolated natural example. So this is you can get that. So for example, Edison's bulb, it is a invented or created one. So it is definitely invention which is patentable. And like we all know that the Fleming has discovered the penicillin, and the era of antibiotics started from that. But it's a great discovery. But that discovery, if you want to patent a penicillin, you cannot get a patent because it is a naturally existing, or the penicillium notatum is secreting that naturally. You cannot get that natural compound or natural antibiotic. So its extraction or its purification, you can get a patent, not the penicillin per se. So this is the difference between discovery and invention. So any compounds new use, second use or third use, you cannot get a patent. Or new form of a known substance, any of the polymorphs or isomorphs, any chemical compounds, if you are making it without efficacy, you cannot get a patent. You have to show the, if it is a drug, you have to show the therapeutic efficacy. And if you want to patent herbal formulations, especially mixture of more than one medicinal plants, that what we are getting right now, more inventions. Even during the COVID also, we received a lot of patent applications for the COVID-19 treatment of this through the herbal formulations. And all these polyherbal, they have to establish the synergistic effect. Otherwise, they will be simply admixtures. If they have to show the synergistic effect, then it can be patentable. Otherwise, we will object under section 3, saying that it's an admixture. So individual effect versus the synergistic effect or combined effect. If you show, then it will be patentable. Any arrangement or rearrangement of known devices which are working in a known way, not unknown way. It is working in a known way, then it cannot be patentable under 3F. And method of agriculture or horticulture. Any method which is used by the farmers to protect the farmers, or there is a clause in the Patent Act, that is 3H. So all agriculture methods are out of purview of the Patents Act, because it may cause a hardship to the farmers if any invention which is belonging to the agriculture method. So we are not protecting, but don't take it otherwise. So all equipments, that is devices which are used for farming, agriculture method, whatever the device you are using, if it is novel, inventive, industrial applicable, it can be patentable. Only thing is that the methods only, it cannot be patentable. So same way to protect the doctors at the hospital. So method of treatment or diagnosis of an animal, or human, including the human, is not patentable. So any treatment methods which are new, inventive, industrial applicable, you cannot get a patent in India. So because to protect the hospitals, they are the commercial entities, so it will cause the hardships on the protection monopoly if it is done. So that's why if anyone invented a very good invention on a method of bypass surgery, they cannot get a patent in India, but they can get in US very easily. So if it is in new, inventive, and industrial applicable, you can get a patent in US, but not in India for method of treatments. So all medicinal practices, whether it is Ayurvedic or it is a homeopathy or allopathy, anything which is not patentable. So plants or animals are their parts. So any genetically engineered, whether it is a genetically engineered plant or animal, are their parts. It can be a leaf, root, anything, or it is any, even kidney. If you are making a genetically engineered kidney, all those things, you cannot get a patent in India. Simply they are barred under the section 3J. So here genetically engineered also, naturally existing you cannot get, but even genetically engineered also you cannot get a patent in India. But it is in contrast to the other countries, there you can get all these genetically engineered plants and animals. So but here in India also you can get a patent for the plants, but you have to register under the PPVRF, that is separate act is there, their plant varieties can be protected, but not as a patent. But microorganisms, you can patent it only genetically microorganism, whether it is a LMO, living modified organisms, or GMO, genetically modified organisms, you can get a patent only if they qualify as a microorganisms, bacteria, fungus. So computer program per se is also not patentable in India. If any hardware you have developed to run that software, you require a computer program, then you can get a patent. So the technical effect produced by the software in the hardware, then that software can be patented, but not the per se algorithm you cannot get. So any matter which is copyrightable, so there is a separate IPR which is copyright and designs. So these two are different IPRs, so that are covered under the different criteria. So that's why you cannot get a patent for them. So any mental act or method of playing game, including video games, you cannot get a patent. A presentation of information, like I am presenting patent filing in India. So this presentation of information, I cannot get a patent on that. Topography of ICs, integrated circuits, there is a separate IPR, the SICLD. So that's why there is no patents on that. So the last in the section 3, P, that is any traditional knowledge is not patentable. So whatever the existing knowledge, whether it is in the oral form, generation after generation, it is coming from in the generations. So that knowledge you cannot get a patent. Same knowledge, in effect, if it is that is the traditional knowledge, you cannot get a patent. Like example, turmeric powder, for use of turmeric powder for wound healing. That was patented in US with this number. So it was then revoked, that claim. And neem oil formulation as a pesticide or insecticide. So this is as a traditional knowledge. In India, many people are using in villages as is pesticides, this neem oils. So that was patented in US, in Europe, sorry, in Europe. So it was revoked after objection from the Vandana Shiva. So she has opposed that and it was revoked. And same way, turmeric powder for wound healing is revoked after objection from the CSIR. So this traditional knowledge in effect is not patentable in India. The another section, that section 3A2P, and the another section, that is section 4, any atomic energy related inventions. So no patent shall be granted for them, whatever the material which is prescribed under section 20 subsection 1 of Atomic Energy Act 1962, like thorium, uranium, radium, all these nuclear radiation materials, which if they appear in the specification also, we are not granting patents for that without clearance from the Department of Atomic Energy. So that is, we refer that application to them. So after that only we will grant it. Otherwise, we will never grant a grant of a patent under section 4 if any dangerous materials are used in the specification. So these are the criteria is novelty, inventive step, industrial applicability. If these three are there, you just look into the checklist of this section 3A2P and section 4. If it is not falling, then you can get a grant of a patent. For that, now you have to make a procedural aspects of filing a patent. So who can file? In India, there are three persons they can file, either alone or jointly. By any person who has invented, he will become a true and first inventor for us. So whether it is one person or 10 persons or 100 persons, they have jointly invented, and that invention you are having a full rights. Primary rights will rest with the inventors who are wherever they are working, whether in a university or college or organization or company, wherever they are. The natural persons who are working, they are the true and first inventors, and they get the primary rights, and they can file a patent application or they can transfer it to the assignees. Like Annamalai University's researchers or faculties, they have invented means they can assign it to the Annamalai University. So Annamalai University can also become a applicant. So assignee of a person, that is what we call assignee of a person, but they have to submit a proof of right. So that is, they have to get an assignment from the true and first inventors. The third, if any person who has invented but did not approach the file a patent application, and within that period he has deceased or died, so any other person, so the legal heirs of him can file a patent application. So these are the three, whether any inventor can file alone or jointly, or he can assign it to the companies or universities or colleges, or the legal representative of the deceased persons. These are the three persons they can file. In India, in total, you can file three types of major three types of applications. One is the ordinary. So today you want to file application, you can file ordinary application. That will be first time you are filing in this country, it is becomes a ordinary application. Or someone else has filed in US and later on he wants to enter it to India, he can either conventional or PCT national phase. He has filed an international application and then you want to enter it to a national phase in India. So these are the three major types. Based on that three, they can file patent of edition, divisional application. So there are totally, we receive 5 types of patent applications. Now coming to the aspect of, so I have invented, which I checked through the Google, it is novel as on date and inventive for my knowledge. It has been done by a research and it is industrially applicable. And I checked section 3 and section 4. It is okay, it's not falling under any of this. So I have a product and making a process for that. So if that is there, so what are the physical requirements to file? So minimum formal requirements are, at least to grant of a patent, you require 4 minimum forms. That is form number 1, which is an application form. Form number 2, which can be filed either provisional or complete. I'll just tell what is the provisional and complete after 1 minute. So form number 3, which is a statement of foreign filing, because it is a territorial right. You can file in any country. So that information you have to provide it to the patent office if you have filed anywhere outside. If it is not filed, nil statement. And form number 18, normal request, or 18A, expedited request. So request for examination, you can file form number 18 or 18A. So at least these 4 forms, if you have filed, then only you will get a grant of a patent. If you want just a publication, then you need not worry about form 18, because the fee is there for form 1 and form 18. The application fee we will give for form 1 and form 18. So but 2 and 3 are, if it is a form number 2 within 30 pages and within 10 claims, then it is same fee with the form 1. Otherwise, additional fee you have to pay. Now form 1, how to fill up the form 1? Form 1 is a simple format. You will get in the website, you can download, and this is a format. So who is the applicant, name, nationality, address, and who are the inventors. It can be 1 applicant, or it can be 10, it can be 100. There is no limitation. Inventors also 1 or 10, it can be any number, n number. So name, nationality, address, title, then address for correspondence. Is there any same application filed anywhere outside India? You are taking priority, then you have to give priority particulars. If it is an ordinary application, 5 and 6 will not be applicable. Then inventor has to declare if he is assigning. For example, Annamalai University is the applicant and inventors are from the Annamalai University. So they are assigning, they have to assign this declaration that we the inventors assign this to the applicant mentioned above. So that declaration will be proof of right. After that, there are some declarations you can just tick or not to tick. So you have to sign, and this is the form number 1. And the most difficult part is the form number 2, where all people has to be taken care while drafting a form number 2. This is the application protection, whatever you are getting monopoly based on the form number 2 complete specification. So there all the details of your technicalities of the invention has to be given. So how that form is there as per the rules? It is title and applicant, name, nationality, address, and the preamble. So you can file this in a 2, provisional as well as complete. Provisional means you need to write the following specification describes the invention, and complete means the following specification particularly describes and the manner in which it is performed. The details of the manner of manufacturing or manner of doing that invention you have to give in the complete. Then next page onwards, second page onwards, description will start. That is what the first page is, this one up to preamble, and second page onwards it will start that description, claims, date and signature, and abstract. So you can file provisional. So what is the provisional? What is the complete? So provisional should describe the nature of the invention and contain the description of essential features of the invention. So what provisional may not include is the details of manner in which. No need to include claims, monopoly claims, and no need to write anything of the details of results, discussion, and materials methods. All these sections you may not write in the provisional. So why provisional need to be filed? It is interesting that So provisional application specific, it's not there in all countries like US and some countries only. India is providing this provisional facility. What is this provisional facility? Is that here, so today you are want to start a research. So you have idea, you got a idea and you want to start a research. But since the patent office follows the first to file, if you are taking 1 year or 2 years time for completion of research, before that someone may file a patent for the same product or process, then you will be the loser. So that's why the government is giving you option that today you are starting that research, you can protect your priority by filing a provisional application. It's an idea. So and little bit the technicalities how you are going to do that invention. You are not worked out with that invention. You can file that invention for just priority protection. One, and the condition is that within 12 months you need to file a complete specification. If you are not filing, it will get abandoned under section 9(1). So you can file another provisional also, but within 12 months you need to complete your research and drafting of a complete specification, and you need to file a patent application. Otherwise this provisional will be waste. So you need to file this provisional at the stage. In another 6 or 8 months you will complete your research work. At that stage you can file a provisional and complete it within 8 months, and then within 4 months you can draft a specification and file a complete specification. So that's how this will work. You will get a additional 1 year priority. So to take the advantage of this system, you need to file at the appropriate time, because it will protect the priority. So though you are just getting a today idea, so till that only you will be checked with the novelty and inventive step. We are checking novelty inventive step when provisional date only. So that's why this is important. Who has filed a first to determine provisional application will help you. And when coming to that drafted complete specification, it must generally, we will see with my experience, I have compiled for you what are the subheadings in that. So title of the invention, any of title is required to be filed. So title must be there, and field of the invention. It is up to field of background, advantages, objective statement. So these are not from the act. So these, but if you give these things in a specification, which will define or describe very properly the invention. So field of the invention, background of the invention means literature. Whatever you have searched the literature, whether it is through Google or some other PubMed or Science Direct. So whatever the literature you have, you can just mention in the background. And important point is that advantages of your invention over the literature, that is over the prior art, you just give it, because it will be easy for an examiner to judge your inventive step. He can easily judge the novelty, but inventive step he may not be easily judging that. So in that case, if you give advantages over the prior art, so then it will be easy. Then objectives of the invention, then statement of the invention, detailed description with the drawing. This is the most important part. So detailed description of the invention with drawings or examples, you need to mandatorily give it. But what, in my experience, I can say that Indian applications, which we are receiving mainly from the academic institutes, they will not detail their invention in the specification. And later on, they will regret that, because we cannot grant a patent where insufficient description of the invention. So when it is a chemical or biotechnology invention, you need to give at least one working example. That is sample preparation of a product or process. Whatever you claim, you need to describe with that. Otherwise, it will be insufficiency under section 10(4). So, and examples, if you are not giving, we will never come to know that what is the specific invention you have done. So that's why to demonstrate invention in the specification, you need to give one working example mandatorily. And if it is a mechanical device or electronic device or system or anything, you need to give a drawings or figures that will explain what is the invention. So any drawings or examples, whatever the requirements for your invention, you need to give in the specification. And then comes the claims. And these are the crucial claims, because that is what we examine. For novelty, inventive step, industrial applicability, we and section 3, section 4, we check with the whatever you have given a claims, and the abstract is just for the publication. So what the act says that section 10(4) A and B provides us fully and particularly describe the invention. So these subheadings are given by me, not in the act and rules. So the act and rules will only specify some of these, and 10(4)B says that disclose the best method. That is working example or drawings or figures, flow charts, whatever you can give it to us. So that is what it will be. So this invention, when you are describing, if any biological material is used from India, you need to provide a NBA permission. That is also a requirement under the Biological Diversity Act. And if any microorganism is used, isolated or genetically modified, so if it is not available to the public, then you have to deposit in the International Depository Authority, IDA, under the Budapest Treaty. These are the requirements. But what the Act says that at least one claim should be there in the complete specification. So to know how to draft each subheading, so title of the invention. Title must be within 15 words, indicating proper scope and claimed subject matter it should describe. That is what about the title. So you have to search the background and advantages. So prior art search you have to do. Though under the act it's not mandatory. Even though without prior art also we can grant a patent. But if you are giving a prior arts and advantages over the prior art, inventive step establishment will be easy for you. So objects are to define the goal of the invention. Statement will be verbatim purport for the claims. So whenever you are making objectives, so more than one objectives may be there for your invention. It will be what is the objective and how it will be an advantage to the society. All these things you can give it as objects and statement. Whenever the summary or statement you are giving, it will be a support for the claims also. And as I said, it is working examples or drawings or figures, they will be meeting the section 10(4) A and B. These are the crucial parts of the specification. Without this, we cannot grant a patent or any invention, any wonderful invention you are making. So without these, either in the example form or sample preparations or the description in a particular description, best mode, all these things, without that we cannot get a grant. So claims, when it comes, you can file any number of claims. One first claim is always independent claim, and based on that you can make any number of dependent claims, whether it is single dependent or multiple dependent. So three types of claims you can make: product claims, process claims, process or method or synthesis, whatever you can call, or use claims. But use claims, anyhow, we are not granting a patent for the use in India. Some countries allow use claims, but in India we don't have any claims for the use, but product or process, because our section 2(1)J started with that. So it says very clearly new product or process. So only product and process only we are looking at. So in product, again you have a chemical compounds or composition or apparatus or article. So for example, if you take a chemical compound, that is Marcus claim, a compound of Formula 1. So you have to describe what are these elements which are defined other than the elements of the periodic table. If you are given anything, you need to describe with the like R1, R2, A, which has to be described. It's a process claim, a process for manufacturing of Formula 1. So then reacting this with this. And when you come to the composition, that is also a product claim, a pharmaceutical composition like this. You can independent claim, first claim, and second claim, which is a dependent claim, third claim, which is multiple dependent. Like this, you can make a claims. And when it comes to the biotechnology, you can claim product as a genes, DNA or RNA, nucleic acids, or it is a protein. So, but there you need to give the usefulness of that gene or protein. Without that, we cannot get a patent there. So, whether it is an antibody or polypeptide, nucleic acid, all these things you can make a. So, once you are completed the drafting of form number 2, form 3 is also one page. There, if you are not filed anywhere, nil. And form number 18 is also one page. You can file whatever the applicant orders are. So these 4 forms, if you are ready, you have to file a patent application. So with what fees? Then comes the fee filling. So for natural persons, any number of natural persons, startups, small entities, educational institute like Annamalai University. So you have to file 1600 for the form number 1 and 4000 for the form number 18. That form number 18 you can file on day 1 or you can take up to 48 months. 4 years time is given. It is up to you when you want to go for the grant of a patent. But in the patent office, your examination queue will start once you file the form number 18. Without that 18, we will never grant a patent. So now the 18 is a mandatory requirement. So all these 4 categories, 1600 and 4th. So those who are not other than this, any 4, so then they have to file 8,000 plus 20,000 as a form 18 fee. And these are online filing fee. And offline, it will go 10% additional to this. So 1,600 will become 1,750 and 4,000 will become 4,400. Same thing, 8,000, 8,800 and 20,000, 22,000. So the offline fees is 10% additional to these all fees. So as I said earlier, expedited within 8 months, you want to patent, you have to either you are a startup company or you have filed an international application, India as a ISA, or all are natural persons and among them one is at least women applicant. Then or any government department or institute, university, organization is filed, state or central, so they can avail the facility of the expedited examination. In that case, form number 9 has to be filed because 18 months is the normal period for publication. Within 1 month, you want publication means you require a form number 9. So form number 18A, that is the expedited examination with a double fee. So 4,000 will become 8,000 fee. And advantages of expedited is within 1 month you will get a examination. Whatever the pendency in the patent office, irrespective of that, you will receive a first examination report. If any objections are there within 1 month. So, and the maximum, it will take 8 months for the grant of a patent. So this I already. So you can file a patent through e-filing with a digital signature certificate. If you have a DSC, either from TCS, Encode, eMudra, you have provided with that, you can file e-filing. Otherwise, e-signature, OTP based also, you can through our office website, you can do that e-signature also. For physical or offline, by hand coming to the patent office, based on the jurisdiction, you can file at the patent office or by post also you can file. So the territorial jurisdiction for filing offline only. Online, when you enter PIN code, it will automatically take it. But when you want to file a patent by coming to patent office, if you are from Tamil Nadu or any southern state, you have to file at Chennai patent office. Otherwise, you have to file other jurisdictions, Mumbai, Delhi, and Kolkata. There are 4 patent offices. So once you have filed a patent application, form 1, form 2, form 3, form 18, then it will be with a fee, whether it is 1600, 4000, it will complete the filing of patent application. So the first and foremost duty of a patent office is go for the publication, whether it is early or 18 months. So if it is pre-grant comes after publication, any public can give pre-grant, whether it is Indian or foreign, anyone who access that, they can give a pre-grant. So whether a pre-grant is there or not, we will examine and grant it, the patent if it is merits. Otherwise, it will be rejected. That is the simple. After grant also we publish, and any person interested can give a opposition, that is called post grant opposition. So quickest time one can get is 8 months, and in normal time it is 27 months. That is what the, so now in some field of technology like chemistry and mechanical, so you will get within 8 months also possibility, but in case of biotechnology it is little bit 2 years, more than 2 years it will be taking. So I'll just brush aside that there are patent examiners can be joined with MSc in various subjects, BE, BTech in other, direct examination will be there. And in courts, anyone can, they can become a patent agents. They can also practice in the courts or other legal procedure if they have a law. Otherwise, they can become a patent agents. So the source of information, you can get a lot of information on this IPIndia. That is Patent Office website, ipindia.nsc.in, wipo.int, and EPO and USPTO. So through this, whatever I have explained, how to file a patent application. So take the, my suggestions are that, so whenever you have done any invention, you just check with that whether it is novel, inventive, industrial, applicable, and check with the section 3 and section 4. So if it is not, then you can just go for a filing of a patent and take the advantage of the benefit of the patent system. And as I said earlier, so the drafting is more important. So you need to keenly draft your specification with title, field, background, advantages, or and detailed description, claims, and abstract. So these things, if you are done, so you will expect that no much objections will be there from the patent office to for the grant of a patent. If you are not drafting properly, so then we may give lot of objections, and then you have to correct all those things. It may take time consuming and delay in prosecution. So otherwise, see, if you are well drafted, it will be easy for the granting by us also. So utilize the patent system for organized R&D activities and capture the global markets judiciously and earn profits through the protected markets. You can, India can benefit from your research. The through the protections and global economies in India's position can improve. So this is what I just wanted to share with you all. So I thank organizers and Annamalai University, and special thanks to Karthik Kumar sir for giving me this opportunity. If any questions, I just read one question in the chat box. So is there any FDA compulsory for getting a patent on the drugs? It is not necessary. We are not looking at the whether this any regulator, whether it is a drug controller or FDA approval is there or not. It is immaterial. So we only check that whether it is novel, inventive, industrial applicable or not. So, and it is patentable under section 3 or section 4, and section 10 it is there as a drafted properly or not. So apart from that, we are not looking at any other regulatory requirement is there or not. Of course, NBA is a regulatory side requirement when you are taking biological material from India. Otherwise, there is no that. So you can get a grant without FDA approval also. So that is what I can say. So there are questions which in the chat box. So I have a question. About 3 to 4 years back, I made a thesis on a unique topic in banking for which I was awarded a PhD. Now can I get a patent of my thesis? So if your thesis is already in public domain 3 to 4 years back, then you cannot get a patent for the same whatever the published information is there, because we will cite if it is available in the publication form to you for you only. So you cannot get if it is published in the public. If it is not available in the public domain, it is kept secret, then you can check for the novelty and inventive step, then go for the filing of a patent. And is this patent valid for internationally? So patent is a territorial right. If it is granted in India, it is only valid in India. If it is granted in any country, according to that, it is enforceable only in that country. So no, it is, if it is granted in India, it is not internationally applicable. For filing, there is a facilitation internationally through international filing or PCT, Patent Cooperation Treaty. So can individual file a patent? Yes. Without any patent agent, definitely you can file it. We welcome generally the direct filings because you know better than anyone your invention. So we expect that patent applicants directly drafts, they will draft a very good up specification and good information you will give. So we expect that. So you can directly file. There is no mandatory requirement of a patent agent. Suppose, yes, if one has written a, then according to can we file a patent? Sir, if book is there, that is a copyrightable. It's not for patent. Book, it is copyrightable. So book, story, novel, literature, anything you can get a copyright. Suppose if I patent once, if there is any mistake, shall I apply once again? Sorry, sir, same invention you cannot get it because it's already in public domain. Once you are getting a patent means it is, we are publishing. So if any mistakes before publication you are making, then you can withdraw that application and refile it by correcting that mistake. But you cannot get a patent once it is published. After that same invention, you cannot get a patent for more than once. Sir, we will have opportunity to change our mistakes after filing. Yes, it is within the scope of your product or process, you can change it. So you can do it amendments, but section 59 will apply there. Is it within the scope of your invention or not? You cannot claim something else. I was claiming, now I want to change it to something else. You cannot do that. Okay. So currently research on the mental health of refugee students in COVID-19. Can we file a patent for topic? So research on the mental health of a refugee students. I did not get whether is there any product or process. If there is a product or process, novel, inventive, industrial applicable, then definitely you can. Otherwise, you cannot get a patent, which is just a study. Outcome must be there. So there must be a product or process for making any product. So if any work published in any journal after patent filing, but before acceptance, would it be approved by patent office? So any publication which is done after filing date of a patent application, we don't have any issue. So we will grant a patent. We only search before filing date of a patent. So today someone files a patent application. Tomorrow you can file a patent journal publication. There is no issue for a patent because your patent is having a priority date of a filing, whether it is a provisional or complete. From that only we will take it. If any work associated with multiple, what will be the formalities? So multiple organizations, they have invented any inventions, so they can file it. There is no, you can combinedly file because multiple organizations, you have a MOU between you. Whatever the understanding you have, you can file a patent applications on both organizations or several organizations. You can combine and file a patent applications. So we are not having any objections on that. You can one organization or many organizations or inventors also can be part of applicants. We don't have any issue. So to attend hearing of a FER, should we have legal knowledge or inventors can attend? Any inventor is welcome to attend the invention, but only the reply should be filed by the applicant because the applicant is getting the rights, not the inventors. So whoever is the applicants, they can only have a right to file. do patent filing fees is different for different products? No, sir. There is no change in the filing of any technology or any product, any process. The same fee, 1,600, 4,000 or 8,000 or 2,000. Only basis of the applicants is the criteria for fee decision. If a product is patented, then after can we publish the paper regarding it in a journal? Yes, you can publish it. Before, after filing, anytime you can publish it, or after granting also you can, definitely you can publish it. So I hope I have taken all the questions. So thank you, sir, once again. I thank. So over to you, sir.
Sir, there's a
Yes.
question in the YouTube viewer, sir. Will you examine the
Yes.
process and product at your end? Will you examine the process and product at your end?
Yes, not the product by practically. On theoretically, on novelty, inventive step and industrial applicability and the drafting requirements only we will examine. Not the testing of a product or process. We are not doing anything because we don't have any facilities. Whatever you have written, we believe truly 100% it is working. So there is no question that we will come and examine that whether it is working or not. Because if it is not working, it is a waste for you only, because we are not. No one will take technology transfer from you if it is not working. So we are not examining the product and process. We only examine the on paper only. Yes, ma'am.
Any other questions from the participants? If you want, you can post it. I'll wait for
So
5
one last question is there with respect to inventor benefits or applicant's benefit if someone file patent in India and other countries. So definitely they can file, but they can assign it. But I am not getting it. Benefits with respect to inventor benefits or applicants benefit if someone file patent. So there are government organizations also, they are taking it care of these filings also on behalf of inventions after evaluation, like NRDC, National Research and Development Council, Government of India is taking care of that type of. So if applicant himself is not able to file, so they are acquiring and they are filing on behalf of applicants and inventors. There is a possibility there. So I am doing PhD in developing a teacher education model. I will submit my PhD within 3 months. Can I get a patent in the area of education? If so, can I apply now? So PhD in developing a teacher education model. So generally these models, if it is any product is there, like kit, teaching kit and all, you can get a patent. But only a theoretical or maybe a software type of things, you may not get a patent. You have to go for the copyright. If you have a vendable product, so you are anything selling product is there, and for making of that product or that teaching kit, you can get a patent. Not if it is there is no product, then it is only a copyrightable. What questions will be asked to an applicant during hearing before? Should we have legal knowledge? So I hope this hearing, whenever we call as a controller, we will give hearing notice. In that we are writing the questions. So whatever about your invention, that questions only will be asked, not other than that any questions. Can we check the novelty of our thesis? Yes, you can check it through Google also, google.com. You can check it. So novelty of your thesis, definitely it can be. So once again, thank, because I have another meeting to attend. So thank you all for joining.
Shall we wind up the session, sir? Shall we wind up the session, sir? Okay, sir.
Yes, ma'am.
Gowda sir has started his lecture with the what is invention, what are the criteria for invention, that is the novelty, the inventive step, and capable of industrial application, that is his utility, was explained nicely. He differentiated between invention and discovery. He has listed out the items that are not patentable and who are the persons who can file, what are the different types of patent application, what are the documents required for patent application, and what are the different types of publication, how much time it will take, whether it is 8 months or 27 months, and what is the fee structure. Everything you have given in detail, sir. Our participants have also given. It's a very useful lecture and very informative. We are very happy to have you, sir, amidst us in this session. Thank you very much, sir, for your wonderful presentation.
Thanks,
The
ma'am.
participants' remarks from the also shows very informative, highly useful, and all these words shows that your lecture was really received by the participants. Thank you very much, sir, for being with us
Thank
and
you.
sharing your expertise.
Sure,
For the
ma'am.
sake
Thank
of
you. Please provide the participant list. We will issue the certificates from our office.
Okay, sir. For the sake of participants, the second session will start at 2:30, sir. You can join from 2:15 onwards. Thank you, sir, for sparing a valuable
Thank
time
you.
and being with us. Thank you once again.